All right. Welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. I'm Melissa Gregg. I'm a financial mediator and business valuation expert in St. Louis, Missouri. And today I'm speaking again with Kelly Lise Murray. She is a lawyer, a professor, a legal scholar, Stanford and Harvard law grad, former Vanderbilt Law faculty for 18 years, and host of the Wealth Litigated podcast. We told you we'd be doing a series on case law, and today we have two more cases that kind of followed our last case about talking about when like evidence goes wrong, right? And when it's weak, when it's completely missing. We have two cases that we're going to try to cover in pretty good timing, but they showcase two kind of different issues. So we have Rothwell v. Rothwell out of Arkansas, and we have Horgan v. Horgan from Texas. And today we're basically talking about like the truth about expert testimony, like what actually holds up in court and maybe what doesn't. So Kelly, welcome back. How are you doing today?
Hi, Melissa. I'm doing well and excited to share these cases because we have some divorce drama happening.
Yeah, no, to get us started, where do you want to start? Because I think these are two good ones, and maybe two that people wouldn't expect could happen, because everybody plans and gets two experts and, does all the things. But like, what if you don't check all the boxes, right?
That's the right question. The Rothwell case from Arkansas is a what if you don't example. Husband and wife, married, no children. Years later, after they have a successful business that the wife solely runs, she is the sole shareholder of this corporation, but they agreed smartly in the divorce process that it was marital property. So they didn't have to litigate that part. But in 2020, she removes him from the board of directors and bans him from the building of the company. So a different corporation owned the building. She owned that corporation, and then her primary business leased it. But the husband's removed from the board of directors. He's banned from the building, and then he files for divorce. They litigate for years, and what is uncovered is fascinating because even though the wife is running the business, which is a bank IT consulting business, she has significantly large banks as her clients, and she's the one running that business. The husband is handling all their personal finances, and this becomes relevant given a valuation before the divorce trial of the business that conflicts with the wife's business expert. This is an example of you need to be careful what you're agreeing to because it's all evidence and it was used against her. We're going to see whether it worked, but it certainly made things more spicy when she had to testify and she was cross-examined with this other evidence. But basically, the business itself had some challenges at the time of the divorce because as a bank consulting company, they were dependent on their bank clients, and one of their largest clients merged with an even bigger bank. And because of that, there were some changes in their prospects. There was a failed sale that also came up. But at the end of the day, only one of the spouses had an actual business valuation. One spouse had a business valuator with 45 years experience. He does 25 business valuations a year. On the other side, the husband testified because he handled the personal finances for this marriage. He brought in a rebuttal expert, no expert opinion, just a rebuttal expert who happened to be an economics professor. So if we just stop there, what do you think would be more reliable for the court to rely on when valuing this business? The actual business valuation expert report or merely rebuttal evidence from an economics professor?
Well, I think that we're probably going to get into some of the issues of a rebuttal expert and I think, a lot of this from a credential standpoint, even the credentials that are out there for valuation kind of deal with rebuttal experts two different ways. There are some credentials that are like a rebuttal expert can really only come in and testify to like them critiquing the first opinion, and not necessarily can they just provide their own opinion because they haven't done all the work, they haven't done their professional due diligence, and a lot of ethics come into it And then there's other credentials that are like, oh, no big deal. You can critique that work, you can recalculate it, and then provide another value. But that's, kind of straddling the line of, are you really a rebuttal expert? Or because a lot of times these rebuttal experts are brought in later, which means the legal team doesn't have the proper time to like depose them, or, so I think there's some gray area in there, but I would say that rebuttal expert can really only come in and say, I disagree with their methodology, their value, but it almost stops there. And can you really provide an alternative opinion or recalculate the value? So I think that's probably going to come into question as they enter those two individuals. But I don't know. Tell me more.
So in this case, the appellate court held, well, the appellate court affirmed the trial court that the husband's rebuttal witness went beyond rebuttal and it was entirely disregarded. Here, let's just take a step back on what the ultimate valuation of this business was. There was a sale that did not go through, and the husband's side was trying to rely on those numbers because those numbers were bigger than the ultimate valuation. And so one aspect, if you just think about it from the judge's perspective, hey, there was a sale and that had a number, but it didn't consummate. The company was not sold. The wife's expert disregarded that entirely. Husband, again, never presented an actual opinion. We had the husband's valuation during the divorce of the business because they have 3 lines of credit and a temporary restraining order that the husband violated. The 3 lines of credit are maxed out to $4 million by the time they get to the divorce trial. They weren't supposed to be maxed out. There was a temporary restraining order. Both spouses were only supposed to remove $250,000. They balloon up to $4 million. The wife is paying the wife's interest payments. The husband's not paying the interest. The wife is $500,000 total in interest just to pay the debt load. Well, 6 months before the divorce trial, they had to file a financial statement on the business's valuation so that the lines of credit could remain open. And the husband prepared that. In this marriage, the husband did their finances, and the husband's valuation is where we're going to start, $19.5 million. And in that statement given to the bank to support continuing the lines of credit, the wife signed and agreed to $19.5 million. But her expert did not value the business at $19.5 million. 6 months later, her expert values the business at $8.8 million. And as you can imagine, the wife is cross-examined because she's agreed under penalty of perjury that this business is worth $19.5 million. And then 6 months later, she's testifying that she is not an appraiser. That's a direct quote. I'm not an appraiser. Now, that could go one of two ways. The wife ultimately prevails, but the point is, you and your legal team during the divorce litigation need to be aware of things where you're on the record giving something of value that your team later wants to have a different value for. And in other cases, that would have rebutted her. Other cases that could have worked. You agreed here that it was 19.5, and now you're trying to say it's only 8.8. You're relying on your expert that it's only 8.8. It's only 6 months later.
Well, and I think that a lot of times in divorce, one of the things that we're asking for, and you've kind of covered some of them, is we're asking for bank loan applications because people will always kind of inflate the value of their business in those. And then have you defrauded the bank? Have you defrauded, and again, so she's kind of caveat. It's like, well, I wasn't a valuation expert, but we also ask for prior transactions. So any offer to buy, any offer to sell. And so I think it's interesting because now it makes sense a little bit to me of like the husband was probably trying to rely on that botched transaction as an indicator of value. But a lot of times we're looking at several indicators of value, and it doesn't quite mean that that is what expert testimony comes in because again, and this might be a little nuance of it, is a deal, like especially a transaction in the company could have been strategic value as opposed to fair market value, so you could even argue and you would need, like, that's where you would probably still need an expert to come in and testify. They could have introduced that evidence of like a prior transaction that came through and what the implication to value was. But the husband probably was just like, okay, let's just introduce the evidence and maybe it'll stick. Like maybe the judge will consider it as part of the situation. So that seems a little flimsy in the evidence land, maybe.
Well, one other interesting piece is the husband testified. We have two cases today where the husband testifies to the business value. In this case, the husband does not run the business. He handles the personal finances. So he was handling the line of credit and their personal side of their finances, but not the business itself. And he testified that he used EBITDA. But then when cross-examined, he couldn't show how he used it. He couldn't show how it contributed to his number. And her expert, the wife's expert, actually used the profit margin. He showed that their profit margins had declined over the previous 4 years, that the loss of the big bank was also a downward pressure on valuation. And his three methods, the wife's expert, 45 years experience, 25 business valuations a year, a single period capitalization, he came out with 6.25 million. His ultimate valuation is 8.8, but that first method, 6.2. Then the second is a market-based EBITDA, which as a lay person testifying, you never want to go up against an expert where you're claiming a valuation method and then you can't explain the math. And then the other side actually explains the math and their math is against what you concluded. So the court ultimately concluded at the trial level on appeal that the husband's financial testimony was not credible. So he basically is not believed about anything. You can understand why. The second one, though, was the market-based EBITDA, and that was 10.4 million. And then the third was marketplace. I'm trying to look at my notes. The multiplier at 10 million. Mm-hmm. And then her expert came out to 8.8 million. The court, using all the evidence in the record, values the business at 10 million. Yeah. That's not going to get reversed on appeal because there was competing evidence in the record. The court gets to make a discretionary credibility determination, and that is never going to be an abuse of discretion. That's the standard on appeal, that the appellate court won't step in when there is the credibility of evidence is being weighed, because the trial judge saw the testimony, saw the person on the stand giving the testimony, and the appellate court doesn't. That's how the wife ends up with a 10 million valuation, even though 6 months earlier she agreed technically to a 19.5 million valuation to support the lines of credit. But that it worked out fine for the wife in this instance. I'm sure it wasn't fun, that part of the cross-examination, but that's not something to walk into. That is something to really try to avoid. Conflicting valuations within 12 to 6 months of your divorce trial. 6 months is not that remote.
Well, I think you bring up a couple good points. One is, the difference between an expert witness and a fact witness. And a lot of times the parties are fact witnesses. So they can come in and testify like these things happened. Like we filed this with the bank and it had this number on it. Like those are facts, right? There's not opinions about it. We had this offer that didn't go through. Those are facts. At the point that you actually have an opinion about the value, I think that that's when it starts to get, difference. And not all states require a large report, to submit to the court. And then there are other states that do. And so it's also like competing, expert report. Oh, this expert has a 47-page report. This expert has a 3-page summary, like the validity, the credibility of the expert, even testifying in court, like even the nuance of looking at the judge whenever you testify, which is awkward. And also the judge sometimes thinks it's awkward, but like, engaging so that they don't fall asleep, like because you can see on their face like when they understand something, or if they're like quizzical and you're like, okay, let me reframe that, something like that, but the other thing is that the judge, and then you see this way more than I do, the judge can literally, two experts come in, either it's the expert and the rebuttal expert in this situation, but they're giving these bookends, and the judge has discretion to go anywhere inside there. Some attorneys might say, oh no, they got to pick one expert or another. For the most part, we're seeing judge have extreme discretion, even to the point where we have some judges that are like, you know what? based on what you guys said, it would make sense for me to take that cash flow or the EBITDA or the cap rate. And I think that, like judges are trying to get smarter in this, but when they get smarter, they're really taking your information. And if they create, like, tell me this, if the judge comes in and says, you know what, I went at 10 million, like in this situation, none of the experts were at 10 million. But
Right.
I came up with this logical way to back it up, and probably in the, judgment, there's the logic of how he got there. What appealable right do you really have to go back and say the judge got it wrong? Like he
It
made up a
always,
number.
you need to look at the standard of review. It's civil procedure. It's not very exciting. It's incredibly important. Your strategy has to be win at the trial level. If you have an asset as significant as your business, you need to put all of your resources into winning at the trial level. You need to get that evidence in the record. Do not rely solely on your own personal knowledge, as Melissa just said, as the fact witness, because you can testify. And we have this case, the husband testified as to value. And in the next case, the husband testified as to value. In this case, he was not credible. In the other case, the husband was successful and deemed credible. You can testify if you own property, but how much weight will the judge give it? And that's really the rub. When I look at what the husband's rebuttal witness came on the stand to say, we know from the appellate decision that the trial court confirmed the economics professor went beyond rebuttal and was completely disregarded. That evidence did not work. And then on appeal, that was affirmed because of that abuse of discretion. It is not an abuse of discretion to weigh the credibility of the witnesses, expert or owner, and their explanations and their facts in the record. But the economics professor, he didn't prepare an independent report. He didn't meet with anyone at the company, didn't meet with management, didn't meet with employees. He listened to everyone's testimony. That's what he testified was the basis for what he was saying from the stand. The failed sale he found relevant, and that amount was 28 million. So the failed sale was for 28 million. Well, it failed. And then 6 months before trial, the husband valued the company at 19.5 million to support the lines of credit. The opinion, and that's how the opinion ended up outside the scope of rebuttal, because he was giving an opinion of value. His value, the economics professor, was 18.7 million. He actually gave an opinion from the stand, which wasn't an expert opinion, and that's not what rebuttal's for. He didn't have any ability to chip away at the wife's expert and what he relied on, and how he came up with his 8.8 million number. And that's how 10 million is within that range of 19.5, which is a document husband and wife signed under penalty of perjury. So that's actual evidence. Doesn't mean we all believe it, but it's evidence. And then 8.8, what judges can do for almost any asset is pick a number anywhere in the middle. And you know what I've been calling that since 2008? Picking a number. It happens all the time with houses. In many states, what courts cannot do is average, because average is mathematically inaccurate. Sometimes you can average, but most of the time, for most assets, you can't average, but they can pick a number. Well, they can average it and then call it picking a number, and it is affirmable on appeal. It would not be an abuse of discretion. The key is property divisions, permanent in divorce. The evidence at the trial level determines what can even be looked at on appeal. And with your trial level decision about property being permanent, you have to show clear error, abuse of discretion. It's incredibly difficult. So you put all your effort into, if the business is an important asset, put your best evidence forward for the divorce trial. If you're going to trial, you've got to get that evidence in the record.
Yeah. And I think sometimes I wonder if people issue rebuttal experts because they run out of time to disclose the real expert.
Right.
And, or sometimes you're waiting for them to give, a credible expert testimony, and it might be a simple case. And so you're like, okay, maybe I just need a rebuttal expert in case they come back and it's not a reasonable position. I think it's just a difficult place to be, because a lot of times the experts will exchange. If you're both an expert witness, you both are exchanging, like that's a realistic way to protect yourself, is each expert creates the report or whatever their testimony is, and they exchange it at the same time. And so a lot of times I think it's a ploy to kind of say, okay, well, you produce your report, we have a rebuttal expert, and we'll wait to rebut it, but you have to understand some of the limitations. And I think some of the
deadlines. You mentioned the deadline. You have to be looking trials here. When does discovery close? Meaning the end of discovery. When do witnesses have to be listed and exchanged with the other side? There's a deadline, and those deadlines are important.
Yeah. And I have seen some rebuttal experts try to sneak in like an opinion and things like that. But I think what you're trying to do as a rebuttal expert is give the judge enough knowledge about how to correct the number in the certain areas. Like, okay, this cap rate is too high by 5%. That would imply a change in value of like, I think that you're implying and showing that. But at the end of the day, I think a lot of judges take the average and then they just they'll almost signal what expert they relied upon most, because if the average was 10 million and they're like, oh, I went 10.2, well, that means whatever, that they kind of felt like that expert was a little bit more credible, had more evidence, which in this case, those were the two main issues, like evidence or no evidence, credibility or no credibility,
actual methodology, or just I'm an economics professor and I know this stuff. I mean, that's basically what the appellate opinion describes his testimony as. It absolutely did not address the two valuation methods used by the wife's expert. And you summarized perfectly how that rebuttal should be structured. You start with one of the valuation methods, and then you show they got the math wrong. You show you and I've discussed this before. Is this even an appropriate method to apply to this kind of business? So that's one way. The facts don't work or the math doesn't work.
Yeah. And like a simple thing is like the income approach. If I was a rebuttal expert, I'd be like, well, they got the cash flow wrong by 100,000 and they got the cap rate wrong by 5%. And judge, how you then factor that is you take the cash flow divided by the cap rate, and then you're going to get to the number. So you almost have to like draw them the picture. But I wouldn't say that's a really great strategy, because you could easily have an expert delineate the actual calculation, because a lot of times if we are the actual expert witness, we are in part of our testimony providing rebuttal. Like part of our direct testimony is to say what we don't agree with the other expert. Like I typically will say, judge, it comes down to two issues. Like here's two differences in our report. He's at 5%, I'm at 20%. He's at cash flow of $1, I'm at $1 million. And once you kind of like, you really do have to lead the judge down the path and not assume that they're going to read these reports, understand these reports. Sometimes I even put together a summary sheet that says like compares the two expert reports so that we can see like what the difference is. And I even sometimes will change the expert's report to be like, if they had done it right, this is what it would have been, so that you're giving it more clarity. But again, best practices, because an interesting thing, do you have anything else to say on Rothwell? Because I think we can talk about the Texas one, which is kind of interesting too. I didn't know about this. But.
Well, there's just one closing thing. So while the wife was running this business and it was a successful business, the husband's annual expenses were $300,000 a year. The wife's annual personal expenses were $150,000 a year. What was he doing? He was gold mining and treasure hunting, but the treasure hunting was in the Philippines. He never flew there. He never met the person he was paying $12,000 a month for 7 years. And he ended up spending $4 million of marital funds on these two ventures, which the trial court equated with gambling. And because it was not a bad investment, when you're good faith investing and the outcome isn't what you wanted, that's not what we're talking about. We're talking about gambling and other kind of dissipation activities. And this was held to be dissipation. And the wife recouped out of the remaining assets, which there were many. She got an additional $2 million back because of his 7 years of gold mining and treasure hunting. But can you imagine paying someone? There's no contract in the Philippines. They're supposed to split the treasure. There was no treasure found. And no profits ever no revenue or profits ever generated. But we don't know that because he never met the person in the Philippines. What if he did find treasure and just never told the person in Arkansas?
Right.
So,
it's a different take on not gold digging, but gold hunting. So
gold hunting, $4 million worth of gold hunting. And while the divorce is going on, he's renovating one of their two houses, $1 million in renovation, $400,000 spent during the divorce.
Yeah.
Usually
And I mean, that's a good
strategy.
point because, marital waste, when people do calculate marital waste, you're not going to get back the whole 4 million. You're getting back, like, it's almost like the court allows you to waste your half, right? He could have gone and wasted $2 million on this endeavor, but he couldn't waste her half. And so her recouping that $2 million is exactly how we calculate it in the property statement as basically an asset that he depleted. So there's a lot of different ways to look at it.